Hello, and welcome to the Washington Monthly. I'm your host, Ann Kim.
And I'm your co-host, Garrett Epps.
Can the government detain you for no reason? In this episode, a primer on habeas corpus, a fundamental principle of American law.
Habeas corpus, simply put, is the right to have a judge adjudicate your detention, and if you're unlawfully imprisoned, to order you discharged. It's a bulwark of American liberty, of freedom from oppressive governments, a check on tyranny.
Our guest is Lee Kovarsky, the Bryant Smith Chair in Law at the University of Texas at Austin. He is one of the nation's leading experts in criminal law and the law of habeas corpus.
Hi, Lee. Thank you for joining us. It's wonderful to have you today.
Thank you for having me, Ann and Garrett.
Let's start with the now infamous clip of the Secretary of Homeland Security, Kristi Noem. She's in front of the Senate, and she's been asked to define habeas corpus, and she completely botches it. So this is Senator Maggie Hassan of New Hampshire who's doing the questioning.
So, Secretary Noem, what is habeas corpus?
Well, habeas corpus is a constitutional right that the president has to be able to remove people from this country and suspend their right to.
Let me stop you now. Habeas
right
corpus, excuse me, that's incorrect.
First of all, Lee, what exactly does Kristi Noem get wrong here? What is habeas corpus, and how do people typically exercise this right?
Habeas corpus, simply put, is the right to have a judge adjudicate your detention, and if you're unlawfully imprisoned, to order you discharged. You can see why it's a bulwark of American liberty, of freedom from oppressive governments, a check on tyranny, all of the things that people use to describe it, and it belongs fundamentally to a person who's seeking to escape their jailer. So when Kristi Noem says it's the right of the president to remove people, she gets it 180 degrees wrong. The joke I made is it's like if you saw a sign that said "Don't feed the animals," and you asked a parent what the sign said, and the parent said, "Oh, it's throw breadcrumbs at the big cats."
Well, tell a little bit about the history of this. This writ goes way yonder back in American history and in the history of English law. Can you give our listeners a little?
Yeah, back in ye old England, when they used these things called writs to do stuff, to order people to do various things, they use what are called habeas corpus writs to move people around. Come into court to testify, move from this jail to that one. And then, in the 15th, 16th, 17th centuries, there starts to be this very specific development of the habeas corpus ad subjudiendum writ, which is the writ that we now call the Great Writ. So it's like one species of the habeas corpus writs. And specifically, it's a writ that a judge issues that orders a prisoner to be brought into court so that the judge can adjudicate the lawfulness of the detention. Originally, it was like kind of a form of royal brand management, the king's realm and dominion. And it was like those were so vast that there were lots of people that were exercising power in the king's name. And so, the crown would actually use the ab subjudiendum writ to call people exercising power in the crown's name to account, so that the king wasn't accidentally attributed the decision to detain someone in some very unbecoming way. Then over the course of the 17th century, judges actually wrest that power from the crown. And what I mean by that is that starting in the 17th century, judges start to issue the writ against the crown, even when the crown orders detention. And that's the fundamental moment in habeas corpus history, when habeas corpus moves from an instrument of the crown itself to an instrument of courts to check the crown, which is its most fundamental form and function and use today.
Mm-hmm. And why did the founders of the American founders believe it to be so important that they actually included it in the Constitution? Like, what happened in the years leading up to the Revolution that led to the enshrinement of this right?
Yeah, so the English government didn't want to hold the American colonists as prisoners of war because that would suggest that they were a foreign country. But they were, of course, English in the minds of the English monarch and Parliament. And so they wanted to hold them accountable for treason. And to hold them accountable under domestic law, what they, and to hold them for those things for a long time without trial, they needed to suspend the writ of habeas corpus, which they did, I think, 6 times during the revolutionary struggle. And the suspension of the habeas privilege during the American Revolution was one of the defining grievances that the framers had against the English crown. And so it was very, very, very top of mind for the framers. The habeas corpus writ is one of only 2 remedies that's mentioned in the Constitution. The other being the no taking without unjust compensation language. And that's just how important it was to the framers. And the scope of the debate at the Constitutional Convention was about whether the privilege could ever be suspended for any reason and not along any other margin. So they ultimately settled on the rule that it can be suspended during times of rebellion or invasion when public safety requires it.
Well, so couple of interesting things about that, and one is that there's not a part of people mistake this, that there's not a part of the Constitution that says the government can suspend habeas corpus when it wants to. It's a limit, right? It's not a grant. But the other question that I think is very foregrounded right now is what part of the government has that? How does the government do suspension legally? Who gets to do it? Who gets to decide?
Yeah, the answer here is clearly the legislature. The anti-suspension language that you referred to appears in a section of constitutional text devoted to restrictions on congressional power. But even more importantly, the idea that the executive could suspend would just make no sense, since habeas corpus is most fundamentally conceptualized as a check on executive power. So it just would be totally incoherent if you set up a system of law in which the executive could suspend a check on its own power. So it's not just formalistically that the language is placed there. It's that functionally, it just wouldn't make any sense if the executive had suspension power. And, in addition to both form and function, we also know all the stuff we know about at the time of the framing and what the debates were about. And none of it ever contemplates executive suspension. The only reason we have that discussion is because Lincoln tried, during the Civil War. Chief Justice Taney said you can't do that when he was writing circuit. And then the legal question was mooted because Congress passed a statute suspending the privilege, thereby taking away the tough constitutional issue of whether or not Lincoln properly did it. Not a tough constitutional issue. I shouldn't have said that, but the contested constitutional issue.
One more question about the language of the exact constitutional provision. It says, unless when in cases of rebellion or invasion, the public safety may require it. Now, Trump advisor Stephen Miller and Secretary Noem have argued that illegal immigration is the kind of, quote, invasion that would warrant suspension, even if they had the power to do that. So how plausible is this argument? What has invasion and public safety meant in the past?
It's not a serious argument. These are, what that's referring to are military offensives by foreign governments. And this is, all the history that we knew before. There's been renewed interest in what it meant for something to be an invasion or predatory incursion, because that's the language that appears in the Alien Enemies Act. And even as people go back and look at all of that source material again, over and over and over, I think every single court to have reached the question has said, no, the arrival of undocumented folks is not an invasion as contemplated by the people who either wrote the Alien Enemies Act in 1798 or framed the American Constitution. And again, I just don't think that's a close question. I think the closest that the administration could get to a victory there would be a finding by a court that it's what's called a political question, which is the idea that, well, if the appropriate branch makes the determination, it's not for courts to decide whether that branch has made it correctly. But I don't think any court is ever going to reach that question on the merits and say, okay, the arrival of undocumented folks, even en masse, is an invasion.
Well, you have written, and this obviously is going to be foregrounded pretty soon, that some people have questioned whether the habeas writ can reach non-citizens. Can you tell us a little bit about that?
Historically, the habeas writ has reached everybody within the protection of the sovereign. That is subject to what we would call the sovereign's legislative jurisdiction. If you have to obey the speed limit, if you're held in the sovereign's jails, if you're subject to its criminal law, if you can be, basically, if you lead your life subject to the rules of the American sovereign, then you can be protected by the habeas corpus privilege. That's traditionally the way it's worked. It's the way it worked in England before you had these questions about the American constitutional environment, and the way it's worked in the United States. After all, we've enforced due process rights through habeas corpus proceedings in America for well over a century. And by definition, if you're talking about a deportation or exclusion proceeding, you're talking about somebody who's a non-citizen. And so that is like deeply embedded in our tradition. Now, there were some questions that started to percolate during the War on Terror cases after 9/11. And those questions surrounded whether or not people who were in functionally American custody who were non-citizens and held abroad as enemy combatants, that is, not as POWs, whether those folks had access to the habeas privilege as a matter of constitutional law. The court, of course, in Boumediene v. Bush says that, yes, if they are held in a facility like Guantanamo Bay, where the United States government has de jure sovereignty, then, they are entitled to the habeas privilege. So if you're being at all faithful to existing law, any human being held on American soil or at a facility that is subject to a de jure American sovereignty should have the habeas privilege. And so the frontier that I expect that the administration will test is holding non-citizens at places not subject to de jure U.S. sovereignty by asking foreign governments to hold non-citizens on America's behalf. And that second scenario is the thing you're most clearly seeing with the CCOT scenario, where you've got El Salvador holding alien enemies detainees and some other categories of removed folks at the behest of the United States government in some way, and the United States government defending in habeas corpus proceedings, saying, you don't have any jurisdiction over us because we're not the jailer.
Actually, you anticipated our next question, which is exactly that. Like, say that you are a legal immigrant who has been scooped up by ICE and deported to El Salvador by mistake. What would the legal arguments be on both sides? How do you break down that analysis?
So the way it has traditionally worked is, the habeas privilege would spread anywhere where you were subject to sovereign custody. So if you were in U.S. custody, then you could avail yourself of the privilege to contest that custody. That gets muddied a little bit in some of the Supreme Court cases, but that's still the basic parameter. Now, the question is, what happens if you are not in U.S. custody? And the administration is arguing that if the Salvadoran government is holding these folks pursuant to a contract that it has with the United States, then these folks are not in United States custody. And for that reason, those people cannot avail themselves of the habeas privilege. That is, they cannot enforce their due process rights. They cannot enforce judgments that their removal may have been unlawful just because there's no remedy. That's what the administration says. Now, courts are pushing back on that, and they're doing that using the doctrine of constructive custody, which basically says, look, fine, maybe the person who's actually holding your key isn't a United States official, but even the person holding the key to your cell is not a United States official. If they're doing so under like a contractual arrangement with the United States, then you're still subject to something called constructive custody. And if you're in constructive custody of the United States, then you can avail yourself of the habeas privilege. A federal court can order you discharged. Now, the question that comes next is, if a federal court does order you discharged and you're not discharged, how is that order enforced? Do you enforce it, a contempt citation against the U.S. official that's facilitated the constructive custody? You can't really enforce the contempt order against the foreign sovereign. So I think you get into some really murky questions there. I think that it's probably much easier to bring the folks from CCOT back through contempt proceedings against officials that sent them there unlawfully.
You introduce a really interesting term in one of your recent articles that actually may become quite important, and that is this idea of negative equity, that there's comments in the jurisprudence suggesting that judges, really don't need to grant habeas corpus if they think, there's some reason why they shouldn't. Even if you show I'm being held, I need an explanation of the lawfulness. They interpret the word may in the statute to mean, well, the judge may if he feels like it. That's a vulgarization of a very subtle point you made. But would you like to tell us a little bit about that? Because, trends in habeas are suddenly very concerning to people.
Yeah, well, a lot of what we talk about when we discuss modern habeas law is a specific pocket of modern habeas law. And that is habeas law that applies in cases where someone who's been convicted and serving a criminal sentence seeks post-conviction relief. And even more specifically, we tend to talk about it when someone who's serving a state criminal sentence is seeking post-conviction relief. And the modern conservative wing of the Supreme Court has marinated in, honestly, like decades of really flawed scholarship about the history of that legal doctrine. And it's now finding expression in majority opinions that are just extremely hostile to the idea that lower federal courts would sit in judgment of state criminal convictions that have been affirmed by state Supreme Courts. So it's in that specific context that you've gotten the most extreme registers of a hostility towards what we're calling habeas corpus. But again, it's in that very specific scenario. Not the scenario we're generally talking about when we're talking about folks that are subject to removal orders in the cases that are dominating the headlines right now. But a consequence of the justices' sort of like incandescent fury at post-conviction relief for state prisoners is they use language about a habeas statute that is applicable to all types of detention to sort of implement their preferences or their view of what the law should be about this one particular type of habeas law that governs prisoners seeking post-conviction relief for state criminal sentences. And specifically, there is language in the habeas statute that sort of distributes judicial power across Supreme Court justices, circuit judges, and district judges, and says Supreme Court justices or some other judges may award habeas relief. The alternative is that they're transferred to some other judge, not that relief is altogether denied. That's what the may is doing there. And then there's this other language in there that says, they should fashion remedies to afford relief as law and justice require. And it's the law and justice require language in a statute called 28 U.S.C. 2243 that Neil Gorsuch and Clarence Thomas have seized upon to suggest this idea to which you alluded in your remark just a minute ago that, habeas corpus relief is permissive. It's not mandatory. There may be discretion for a judge who finds that the custody is unlawful to nevertheless deny it. And that idea is something that I call negative equity. That is, it vests discretion in the judge not to grant habeas relief, but to deny habeas relief to which a claimant is otherwise entitled. And that argument is deeply atextual. It's deeply ahistorical. As I mentioned, the may is in a different section from the law and justice language. One's in 2041, one's in 2043. The reference in 2241 to the may, like I said, the alternative if you don't grant habeas relief to someone who's unlawfully detained is that some other judge is supposed to do it, not that the person can be denied relief entirely. And the law and justice language in 2243 is actually supposed to be an affirmative grant of authority to judges to craft efficacious remedies, to do whatever they need to do to make sure that a prisoner who is detained unlawfully can ultimately obtain their discharge. Ironically, what it's supposed to do is the thing that the Supreme Court just approved of doing in the AARP case, now captioned WMM, where the Supreme Court said, you can have a putative habeas class as necessary to enforce notice requirements that will allow them to file their habeas petitions. So it's that kind of power that the law and justice language is supposed to vest in courts. It's not supposed to take any power or away or give them any discretion to deny relief to folks that are entitled to it.
Mm-hmm. If I interpret your article properly, you're also saying that in some cases, judges are denying habeas relief if the defendant is not, quote unquote, factually innocent. And I'm wondering what the implications of that are when you're talking about people who've been detained for violations of immigration law. They are not factually innocent of having violated immigration law. Does that mean, how do those things go together in this context when you're talking about denying habeas?
Well, one of the things that I think is really fortunate is that at the time that I wrote that article, there was a movement in the lower courts to take the idea of negative equity and sharpen it even more so that it became a doctrine that said, you can't get habeas relief unless you allege not only that your detention is unlawful for some way, but also that you didn't commit the crime for which you were convicted. And the lower courts have backed off of that.
Okay.
I like to think that some of the reason they backed off of it is because of the work that I did in the article. It was such, a deeply flawed argument. I am obviously I was motivated to write an article about it, but also because the lower courts don't really have interest in it right now, I would be surprised to see the Supreme Court to import it or transpose it, or whatever the right verb is, into the immigration context. And I think the Supreme Court, especially in the immigration context, hasn't shown any interest in saying like, okay, well, you violated a removal order or a non-removal order, but is this person really part of MS-13 or not? There's nothing that you can look at in the JGG opinion from April or either of the two AARP opinions that suggest to me that they have any interest in that type of innocence rule in removal cases, which is good because if they did show the slightest inkling in that rule, then I think all of a sudden you'd have really aggressive forum shopping from the administration to find judges that are willing to indulge, presumptions of regularity about claims the administration makes about each of these prisoners, and what their affiliations are, and what their tattoos indicate, and so forth. But again, like I actually, as of right now, May 20 whatever, year of our Lord 2025, feel that the lower courts are not interested in that sort of project.
Just to follow for our readers my own incomprehension, I want to make sure that I'm following you. The kind of, you can't have habeas unless you're factually innocent. That is for a state prisoner who's been tried in a state court, right? And they're
That's
alleging,
the context in which...
yeah. And they're alleging that there was something wrong with their trial. Maybe they had a 6-member jury, or maybe the prosecutor introduced evidence or withheld evidence. That's not the same thing as saying I didn't do it, right? I didn't get a fair trial. Right.
Right, exactly, right? So maybe, I'm on trial for robbery and the prosecution withheld impeachment evidence about some star witnesses against me, but I don't, the idea is that, well, I shouldn't get a second bite at the apple. I shouldn't be able to initiate a round of habeas corpus litigation unless, in addition to that showing that the evidence was unlawfully suppressed, I can also show that I'm not the bank robber.
The high bar. A final question for you, Lee. Assuming that one chamber of Congress, at least, falls into Democratic hands after 2026, what do you recommend, given this conversation and everything that's happening, that Congress do to shore up the remedy of habeas, especially given that the article you've written about the concept of negative equity is based on a statutory construction, right? So how would you change the statute, or how would you create a new statute? What would you tell Congress to do?
Well, the nice thing about protecting the privilege, at least insofar as we're discussing the folks that are subject to attempted removal right now, and like these really aggressive immigration actions, is they can kind of just gum up the works. I mean, the real threat, it looks like the administration is going to lose most of these cases under the existing statute, which means to get what it wants, it's going to have to get an affirmative piece of legislation out of Congress. Now, given the sounds that the Republican caucus is making around nuking the filibuster, I'm pretty nervous that there may be a compliant Congress seated for at least the next year and a half. But if one of the chambers falls into Democratic hands, then I think it's easy to just spike any legislation that comes through that would seek to expand executive power, either the substantive power to detain folks, or the power, a power that would restrict remedies for unlawful detention. I think unless they capture both houses and the presidency, it would be very difficult for them to pass their own preferred legislation. And this is the Texas death penalty lawyer in me talking. The value of my career is loss avoidance. But avoided loss matters, and there's a lot of avoided loss that comes with some control of a chamber of Congress. I just think that eliminating the risk that Congress tries to delegate some suspension authority to the president or something like that is such a huge increment of value if you're talking about justice and fairness and the rule of law.
Well, thank you, Lee. We really appreciate the chance to talk to you about this.
Yeah, this is great.
Thanks, Ann, and thanks, Garrett. I appreciate your time and your thoughtful questions.
That's it for this week from the Washington Monthly. I'm Ann Kim, and on behalf of my co-host, Garrett Epps, thank you for listening. If you like what you heard, don't forget to subscribe to our channel or wherever you get your podcasts. Have a wonderful week.